Hi everyone, Jay here from Flow Migration Law. Today we're tackling a topic that can cause a lot of concern. What happens if you've had a visa refused or cancelled while in Australia and you now want to apply for a partner visa? Many people in this situation come across something called a Section 48 bar and assume they have no choice but to leave the country. But that isn't always the case. Before we go any further, just a quick disclaimer. This video contains general information. Australian immigration law is very complex and your situation is unique. So it's important for you to seek personalised legal advice before taking any action. So what exactly is this Section 48 bar? In simple terms, Section 48 of the Migration Act is a rule that prevents you from applying for most other visas while you remain in Australia if two things have happened. 1. You've had a visa refused or cancelled since your last arrival. And 2. You no longer hold what's called a substantive visa. A substantive visa is essentially your main visa, like a student, work, or visitor visa, and it's not a bridging visa. So for example, if your student visa was refused and you're now on a bridging visa, Section 48 would generally apply to you, blocking you from lodging most other visa applications onshore. But here is the crucial piece of information for couples. The onshore partner visa, the Subclass 820, is one of the very few visas that is specifically listed as an exception to the Section 48 bar. This means that in many cases, you can still lodge a valid partner visa application from within Australia, even if you're affected by this bar. It's a significant exception that allows partners to stay together while they apply. However, there is a very important catch. For this exception to apply to you, your most recent visa refusal must not have been for a partner visa. So if your student visa was refused, you can likely use this exception. But if you previously applied for a partner visa, either the onshore 820 or the offshore 309, and that application was refused, then unfortunately Section 48 will prevent you from applying for another partner visa while you remain onshore. There may be a strategy if you're in this situation. So if you're in this situation, it's strongly recommended that you seek advice from a professional. It's a small detail that catches a lot of people off guard. Now, just because you can apply, it doesn't mean the process is simple. This brings us to the next layer we need to discuss. Schedule 3 criteria. If you're applying for the partner visa while affected by the Section 48, you almost certainly do not hold a substantive visa. And when you apply for a partner visa without a substantive visa, Schedule 3 requirements are usually triggered. What is Schedule 3? It's a set of rules designed to encourage people to remain lawful. To overcome this, you must show the department that there are compelling and compassionate reasons to grant you the visa despite the visa status. This means your application has a higher bar to meet. You don't just need to provide all the usual evidence to prove your relationship is genuine, and you also need to prepare a detailed submission explaining your circumstances and why Schedule 3 requirements should be met or waived in your case. This is a really important part of this application strategy. On top of this, there are very strict technical requirements for a Section 48 partner visa application to be considered valid. You'll need an approved sponsorship form signed by your Australian partner and 2 specific statutory declarations from other Australian citizens or permanent residents who can attest to your relationship. A key detail here is that these declarations must be very recent. They must be signed within 6 weeks of when you lodge your partner visa application onshore. Once you lodge a valid application, you will typically be issued with a bridging visa. This may allow you to stay in Australia lawfully while your partner visa is processed. However, it's really important to understand the conditions of this bridging visa, especially around travel and work. So let's bring it all together. A Section 48 bar can feel like a complete roadblock, but for the partner visa, there is often a way forward. The path involves confirming you're eligible for the exception, preparing a strong case to address the Schedule 3 criteria, and meticulously meeting all the technical application requirements. The timing of your application and the evidence you provide are absolutely critical. This is one of the most complex areas of partner visa law. With over 8 years of dedicated experience in Australian immigration law, I've worked with many clients to navigate these exact provisions. My work is focused on providing clear, strategic guidance through these layered processes. If you're affected by a Section 48 bar and are trying to figure out your next steps for a partner visa, I welcome you to book a consultation through our website. We can then assess your specific history and help you understand your options. Thank you for watching.